Welcome everyone. Thanks for coming today and joining us. And again, we want to thank all the veterans and their families who have made sacrifices. And we look forward to going through this seminar with you and just kind of unraveling some of the confusion around veterans benefits. And so I'm going to start off with just introducing the speakers. So Attorney Brittany Smith will be speaking about long-term care planning and how to best utilize the VA benefits that you might be entitled to receive. And you'll see that Brittany is licensed as an attorney in Pennsylvania and Virginia. And Brittany just recently became certified as an elder law attorney, so we are very excited about that. And she heads our long-term care planning department here, so she and I work together with people that want to get their powers of attorneys in place, do pre-planning for asset protection in the event that they need long-term care. And then we also work together in the crisis department. So if anybody who needs in-home care, assisted living, or nursing home care, we're able to assist them through that process. But she also assists with the estate administration. And so you'll see some information up here on me as well. I've been with the firm for a little over 13 years. Working with the attorneys to help people to accomplish their goals. And so today we're going to talk about veterans benefits. And there are two basic types of pensions that veterans or spouses can be entitled to receive. The first one is a service-connected pension. And so that's really a pension for a veteran or the widow of the veteran who has a service-connected disability. And so they typically do ratings based on the level of disability that the individual received during the service. Today, we're going to focus on non-service connected pensions. And that one is one that you will find that a lot of people are eligible to receive if they meet certain criteria. So you may have heard of this pension, also known as the pension for aid and attendance or pension with housebound. So to qualify for this non-service connected disability pension, the first step is you have to be honorably discharged. Or again, if you're applying as the widow of a veteran, the veteran had to have been honorably discharged. There's going to be some family income and net worth criteria that we'll go through in detail. You must have had to have served for at least 1 day during a qualifying war period and at least 90 consecutive days. And that's if you were in active duty prior to September 8th of 1980, or if you were enlisted after September 7th of 1980, you had to have served for at least 24 months. So the qualifying war periods we do have listed here. So the Mexican border period, it's one we're not seeing many people who are still alive that served during that time, as well as World War I and we are still seeing some World War II veterans at this point. The Korean conflict war period, the Vietnam era, there's actually certain dates for that you had to serve. So we have those listed there as well. And then the Gulf War era. Okay. So at least one must be true of this to qualify for the pension. You have to be at least 65 years or older, or if you're under 65, you have to have a permanent disability or receiving care in a long-term care facility or on SSI or Social Security disability benefits. And there are 3 different levels to this pension. And the first one is just low income, permanently and totally disabled. Level 2 is a housebound status, so you have difficulty leaving your home independently. And then the third level is the one we see the most, and that's the aid and attendance. And that's where you require the aid of another person to perform activities of daily living, like bathing, dressing, feeding, things like that. So we see that one mostly in assisted living, or if you're at home and you need to hire caregivers. So that's the pension that most people we work with qualify for. Now the qualifications for this, they're going to be looking at your income and your net worth. And when they look at your income and net worth, they're also going to be deducting out medical expenses. So medical expenses are going to include anything from health insurance premiums, out-of-pocket reoccurring prescription costs, and the big one is assisted living charges. So if you're paying $5,000 a month for assisted living, that fully qualifies as a medical expense. Or if you're hiring caregivers and you're paying, $3,000 a month for those in-home caregivers, that will also qualify as a medical expense. So the different pension rates, and this is also the income limit, but keep in mind the income is adjusted by those medical expenses. But the pension rates are dependent upon whether or not you're a single veteran or a veteran with a spouse. So for the veterans without any spouse or dependents, the regular pension rate is $13,752 a year. For housebound, $16,805. For aid in attendance, $22,939. What that means is that if your income is below that and you fall into one of those categories, the VA would give you a pension to bump you up to that amount. So for the aid in attendance example I gave earlier, if you financially qualify and for VA purposes, your income is all being used up for your assisted living charges, you could qualify for the full pension of $22,939 a year. So then we also have listed here the rates for a veteran with a dependent. So again, that would be a spouse or a disabled child. Anything like that could fall into that category. So the regular pension is $18,008. The housebound is $21,063, and then the aid in attendance is $27,195. Now, if you do have more than one dependent, they do add an additional $2,351 to that income. And so I mentioned the unreimbursed medical expenses. So in the calculation, it has to be 5% above your income limit, as we just outlined. In October of 2018, they set into law the 3-year look back for gifting for VA benefits, but they also set a net worth limit, and that does increase annually. So effective December 1st of 2019 for the year of 2020, that limit is $129,094. So, and we'll go through what that actually means. But that is the net worth limit to qualify for VA. And the 3-year look back was basically pretty new for the VA. They've been proposing this for many years. But prior to October 18th of 2018, you could gift any amount of assets and then qualify for the VA immediately. But now under the 3-year gifting look back, it makes it very difficult to do that. So under the 3-year look back period, what that means is that if you do transfer assets for less than fair market value, then they will impose a penalty or a period of time that they will not issue the pension benefits. If you made any gifts prior to October 18th of 2018, they will be grandfathered under the old law and there would not be a penalty. And the way that they work that is there's a penalty divisor, which is currently $2,266. So for example, if you gifted $70,000 that made you ineligible for this pension, they would impose a penalty of 30.89 months, meaning you would be ineligible for benefits for that period of time. So really when a veteran is looking at applying for benefits, if they had made a gift, it's a good idea to figure out if that gift would cause a penalty greater than 3 years or less than 3 years, and seeing whether or not they should file the application. When counting the assets to qualify for this pension, there are certain assets that do not count. So a primary residence with a 2-acre lot is exempt. Any vehicles used for transporting the family would be excluded. Home furnishings, prepaid burial or burial plots, and again, any assets transferred or gifted prior to October of 2018. So then what they do is they're going to look at your countable assets. So, this could be all your bank accounts, your retirement accounts, cash value of life insurance. They're going to total that. And then they're also going to look at your monthly or your annual income, subtract out the unreimbursed medical expenses, and that's how they determine your net worth. So let's say your countable assets, which would be all your bank accounts, retirement accounts, life insurance, cash value, let's say that's $100,000. Then your annual income, Social Security or pension, would be $50,000. And then your unreimbursed medical expenses after the 5% deduction would be $20,000. So they add that all up, subtract out the medical expenses, and with this example, your net worth would be $130,000. So because you're slightly over the 129 income limit or net worth limit, you would be ineligible for VA. So one of the things that you can do to reduce your assets is you can set up prepaid burial arrangements, you can pay caregivers, you can purchase things that are exempt, household supplies. So there are certain things you would want to do to make sure that you were under that limit when you file the application, because the application process can take up to a year to go through, so you don't want to file prematurely. Okay. All right, I'm going to turn it over to Brittany, and she's going to talk about the
All right, thanks, Tammy. So what I'm going to focus on now is ways that you can actually plan in advance of the crisis and help really shield additional assets that may be over that $129,000 limit. And then also this planning is really effective as well. If you're not particularly looking at veterans benefits, but you might be interested in Medicaid benefits down the road or any other benefits, this planning is really going to be helpful. So, one of the things I hear a lot is, well, I want to get these assets out of my name. Can't I just transfer them directly to my children, get them out of my name, they're theirs, and then, it's free and clear for me to receive these benefits? Well, that definitely is an option, but it's really not one that we would recommend. And that's really because of the 4 Ds. So for instance, say you have your primary residence or you have an investment account that you want to get out of your name. You transfer it to your son and then he gets a divorce. Now that asset that you've transferred to him is 100% his, and it's going to be subject to his divorce action. So your house that you're living in might end up in divorce court and go to your ex-in-law. Nobody wants that. And then the same thing if he were to go out and get in a car accident. Say he has somebody that tries to sue him above his insurance, or he has other creditors looking for funds. Now you could lose your assets to his creditor issues. The same if he passes away. So, say again, you transfer your house to him. He has a last will and testament that leaves everything to his neighbor. You might not even know his neighbor, and now you're going to lose your assets, to whatever his last will and testament says. So we really don't recommend outright gifting because it really doesn't give you the control and the protection that you would want, even though it gets it out of your name. So one of the things that we use a lot here at the firm are actually trusts. And, this tends to be kind of a scary thing that people are like, oh, trusts, aren't they something that's complicated? A bank has to manage. You have to have a lot of money to set up a trust. And that's really not the case. We try to make our trusts as user-friendly as possible. So they're really going to be easy to manage. They're going to be something that you control yourself. You don't necessarily have to get a bank involved. And they really are customizable based on whatever your wishes are. So I like to say, if you have a lot of assets, a family situation that might be a little bit more complicated, you can pack a lot in there like an SUV or a minivan. If it's going to be streamlined and easy, maybe you have one account you want to protect, then it's going to be more like a sports car. So that they really are customizable based on whatever your wishes, whatever your needs are at that point. And there are several types of trusts, and we're going to go through what each of these types of trusts are, what they mean, because again, you can really customize them for whatever your situation is. So there's grantor, there's non-grantor, it can be revocable or irrevocable. And then the one that we utilize the most really is the asset protection trust, because that's really the one that's going to lock in your assets and protect it, not only, if you're looking at veterans benefits down the road, but also if you're looking at Medicaid or other benefits as well. All right, so what are some of the benefits of setting up an asset protection trust? So really what it does is it's really going to help shield those additional assets and resources from that $129,000 net worth requirement. So, like Tammy said, the VA does have that 3-year look back. So the good thing about pre-planning is you could set up a trust, transfer any of the assets that you would want to make sure are protected, and as long as you don't apply for those benefits for 3 years after that, then whatever you put in the trust is fully protected. Okay, you won't have that penalty when you apply for the VA. And as long as all the assets outside of the trust are under that 129, you'll receive that benefit. Okay, so that's one of the biggest benefits to setting up a trust. And then the same with nursing home care. So with nursing home care, a lot of times, if you need 24-hour care, you're in a skilled facility, we're going to be looking more towards Medicaid benefits at that point, because they will actually cover 100% of the cost of your care. So the good thing about these trusts is it's not only protecting for VA benefits, but it's also protecting against Medicaid as well. Now, Medicaid has a 5-year look back, so you would have to stay healthy and out of a nursing home for 5 years after you do these transfers, but it does have the same protection. And then also with Medicaid benefits, Pennsylvania does have what they call an estate recovery system. So any assets that are in your name alone, after you pass away, they're going to actually try to recover them to recover some of the payments that they made on your behalf during your life. So the good thing about trust is it's no longer your asset, it's not in your name, so they can't ever recover it then whenever you pass away. And then like we talked about, any of your beneficiaries that you list in the trust is not subject to their divorce, their creditors, any of their actions, because it is still technically your asset at that point. And then there are some other benefits as well. So again, with probate, most of you have probably heard of the probate process. So that's really, where whenever you pass away, someone has to be formally appointed as your executor to really handle your estate. And that's where they have to go to the courthouse, they have to get appointed, things become public record. The good thing about a trust too is, since it's no longer in your name alone, it actually avoids the probate process. So you don't have to put anything on file, it doesn't become public record. It maintains a lot of that privacy that probate, really doesn't have. And then a lot of times we see too is, you want to leave assets to your children, but they might not manage money well. Say you want to control how and when they would get distributions, you can actually set it up where it would stay in trust, and you can decide during your life how those assets would be distributed. Whether you want them to get $5,000 a month or $20,000 a year, you can really make those decisions. And then the next one, federal estate tax. This really isn't as big of an issue as it used to be. So the limit right now is 11.58 million per person. So if you pass away with more than $12 million in your name, your beneficiaries will have to look at paying this 40% estate tax. Now, we don't see many people in that bracket anymore. I wish I was one of those people. But if you are concerned about this, just know there is some planning that we can do to really help shield those assets as well, because that is a hefty tax, 40%. All right, and then just managing the assets when you pass away, controlling where they go, how they're distributed, all of that's a benefit as well. All right, so really, what is a trust? What do I mean whenever I say a trust? So it's really just a legal document. It's just a piece of paper that you would come in, you would sign. It's a set of rules, and it really determines how the asset's going to be managed, where it's going to go when you pass away, how it's going to be managed during life. And you really have to be thinking about some key individuals that are really going to be essential to the trust. And again, we're going to go through, what these roles are, what they're responsible for. But you really have to be thinking about a trustee, a trust protector, the beneficiaries, who do you want to receive the assets? And then we also include powers and different clauses to make it more manageable as well. All right, so the first individual really is the donor of the trust. This is going to be you. This is the individual who's really setting up the document, transferring the assets to the trust, and it's really fully your decision how much would go in there, what assets are transferred. You maintain complete control over all of those decisions. All right, and then the next role is the trustee. So I like to refer to this as the driver of the trust, because it's really the individual who has the full management and decision-making authority. So a lot of people say, well, I heard that if I set up a trust, I can't manage it. I can't be the trustee. Well, the good thing about our trust is we can actually name you as the trustee. So even though you're transferring the funds to the trust, you're not giving up really any control, because you can still decide if it's real estate, if you want to sell it down the road, you can sell it. If it's stock or an investment account, you can decide how it's invested, when to liquidate it. All of that's still going to be your decision, the same as if, you really owned that asset outright. So that's one of the benefits of our trust, is it's out of your name, but you still maintain a lot of control. All right, so then the next one really is the trust protector. So this really comes in, and this is really the key to how we can let you be the trustee, but yet you can still maintain that protection for benefits, Medicaid benefits, and veterans benefits. So one of the things with our trust is if we allowed you to control distributions. So say we would set it up where you could just write a check, get everything out of the trust, pay it to yourself, you would actually lose all of that protection, because what the nursing home would say or what the VA would say, they would say, okay, great, get everything out of the trust, use it to pay for your care. So what we do is we actually separate out the roles. So even though you can make the management decisions, you would actually appoint somebody else who would have the check writing ability and can make the distributions for you. So a lot of times we recommend at least 2 people. That way there's a checks and balances. So, it could be your children, it could be a family friend, whoever you would trust in that role, that if you would go to them and say, hey, I need $5,000 out of this trust, they would be able to get that out for you. So even though you would be transferring it, you still can, go in through what we call that back door, because life happens. You might need a new roof, or you might need some of that money for a vacation. You can actually go and get that out if you would need it through that trust protector. And then one of the things I hear too as well, what if I name somebody and they refuse to get the money out for me? So one of the good things too is you can actually add or remove trust protectors at any time. So if you would name your son and he would say, I'm not getting that out, that's my inheritance, you could actually remove him and add somebody that would cooperate and would get that out for you. So again, you're not really giving up control, because you can fire them at any point. And then one of the good things too is, for Medicaid and for the VA, for their look backs, they only look at the snapshot, what that account was worth or what that asset was worth on the date that you transfer it to the trust. So say it was worth $100,000 on day 1, you transfer it to the trust, and then, by the time the trust ends, it's, 130,000 or whatever it grows to. There's no additional look back for any of that growth. It's just on the date that you transfer it to the trust. So, say down the road 2 or 3 years down the road, you say, well, I want to give my kids some of that money. Instead of actually having another look back, they're only looking at the date you transfer it to the trust. So you can actually tell your trust protector, I want to give my kids $30,000 out of that trust. And that goes without any additional penalty to you, because you already started that look back right whenever you funded the trust. So that's one of the benefits as well, is if you want to do additional gifting to your kids or other beneficiaries, you can do it down the line, and there's no additional penalty for that. And then we did talk about if they don't follow your instructions, you can remove them. So you do have full power over that. All right, so when does the trust pay out? So this is really where it's customizable as well. So most of our trusts, individuals say, well, if something happens to me, I just want my kids to get it outright, and then they can really decide, what they want to do with the assets then at that point. So it can terminate whenever, both of the spouses pass away, or whoever sets up the trust whenever they pass away, and then it would just go outright then to the beneficiaries. But if you do have some of those concerns about, controlling money, spending habits, maybe you have a child that's looking at a divorce, there is the option where you can actually have it stay in trust, and you can outline the terms of distribution, how much they would get, when it would pay out to them, so you can still kind of maintain that control then after you pass away. All right, so who decides what goes into a trust? So that's really your decision as the donor, the one who establishes the trust. So what we do here at our office is we kind of like to take a look at everything, and we develop a plan of recommendations, but it's always your final decision. If you say, well, I'd really like to keep that account out because I might need it for something, or I don't feel comfortable, you can protect as much or as little as you would feel comfortable with. Now, what can you transfer to a trust? So you can really transfer anything. There are going to be a few exceptions to this, but one of the biggest things that we see is real estate, because even though it's excluded as an asset during life for the VA, for Medicaid, where they're going to come back after it then is after you pass away. So a lot of people say, well, I want to make sure that asset's protected so it goes to my kids, even if I do have this asset during life. So real estate's really the biggest one that we look at, and it's a good asset because it's really just sitting there. You're not using it to live off of for daily expenses. It's not liquid. So it really, the only thing that changes is the title for the real estate. And then anything else, annuities, bank accounts, life insurance is a good one as well, because again, that's an asset that just kind of accumulates. You're not really using it for daily expenses. Investment accounts, savings bonds, really anything like that we could transfer to the trust, get it out of your name, and start that look back for the benefits. Now, there are two exceptions to this. So we actually cannot transfer retirement accounts. Anything that is tax deferred, we're not able to transfer that to a trust, because the way it's set up is you're not paying that income tax until you receive a distribution from the account. So if we were to actually transfer that account to the trust, that would be considered a taxable event, and you would actually have to pay all of that income tax at the time that we were to transfer it. So a lot of times that could be a hefty income tax bill. So we don't recommend transferring retirement accounts. We look at transferring an investment account or real estate or something else that doesn't have those same consequences. And then vehicles as well. So in Pennsylvania, anything that has a title, a boat, motorhome, vehicle, anything like that, we cannot transfer to a trust. The Department of Motor Vehicles doesn't allow a trust to be on the title. So again, that's something that we would really just keep out and keep in your ownership. All right, so what about income taxes? So this is where we get into a grantor versus a non-grantor trust. So the difference really is who's responsible for the income taxes on the asset you put in the trust. So for example, say you put in an investment account, it generates, $5,000 in income. Where does that income get reported? Well, most of our trusts are set up as what are called grantor trusts. So what that means is that all of that income is still reported on your personal tax return, just like you would report it now. You don't have to file anything separate. You don't have to go to a CPA or anything if you do your own taxes. All of that just goes on your personal tax return, and you pay it at your personal income tax rate. So that's really the most user-friendly. So that's usually why we set it up that way. Now, one thing you have to keep in mind, though, is that does make the trust subject to what's called Pennsylvania inheritance tax. So this is a one-time tax that Pennsylvania levies. We're one of a few states that still has it, unfortunately. But what happens is whenever you were to pass away and those assets in the trust then go to your children or your grandchildren, they will have to pay a 4.5% inheritance tax. And again, it's just a one-time tax, and they would pay it at that point. But the good thing is it kind of saves a little bit in income tax during your life. All right, so then the next one is a non-grantor trust. So a non-grantor trust, this is really one that we would have to set up if you are looking at veterans benefits. And the reason we would have to set it up for veterans benefits is because, like Tammy said, for net worth, they're looking at your income, they're looking at your assets, they're looking at all of that for you to qualify. We don't want you to be taxed as the owner of the trust because all of that's going to go on your income tax return, and it's probably going to put you over that net worth requirement. So if you're really looking at veterans benefits, this is really the trust that we would set up for you. It's called a non-grantor trust. And basically what that means is that the trust would be responsible for paying its own income tax. So, whatever you put in the trust, you'd actually have to file a separate trust tax return each year. It's called a fiduciary 1041. We would have to get a tax ID number, which is called an EIN. And then the trust would actually just pay the taxes out of whatever it's holding. And because of that, trusts are taxed at a little bit of a higher income tax bracket, and they reach it quicker than individuals. So the highest bracket is about 39%. And so they reach that a lot quicker. So one of the drawbacks with this is, yes, it protects assets, but we have to be kind of careful about what we put in there. What are the income tax consequences going to be? Where are the extra accountant's fees going to be? So we would take a look at all of that for you. And then one of the things too is, one of kind of the other benefits is because it is set up this way, any of the assets would go inheritance tax free then to your beneficiaries. So essentially with this trust, you're giving up all control over, ownership, income, all of that. So then, the state of Pennsylvania does not levy that 4.5% inheritance tax. So that's everything that we would look at before we would make a recommendation of which type of trust to establish. All right, and then I've been kind of talking a little bit about Medicaid. So what about Medicaid? Don't they have a look back? And they do. It is that 5-year look back. So the way that works is, if you were to transfer assets to a trust and need care within 5 years and you apply for Medicaid, they would have a penalty that they would impose as well. Just like the VA has the 3 years in their penalty, Medicaid is a little bit longer, it's 5 years. So the way their penalty works is for every $10,732.83 that you give away within that 5 years, there's 1 month that they will not pay for your care. Okay, and the way that they get that number is that's really the average cost of care in Pennsylvania, and it does change each year as well. So this is just the 2020 number. So for example, how does this work? So if you were to give away your house and say it's worth $200,000, there would actually be a penalty if you would need care within that 5 years of 18.6 months. So they just take the 200,000, divide it by the 10,000, and that's where they get the 18.6 month penalty. So what that kind of means realistically is, say 3 years into your look back, you have an incident, you need to go in the nursing home, you apply for Medicaid benefits. They would say, nope, you transferred assets you could have used to privately pay. We're not going to pay for 18 months. So then what you would have to do at that point is use other assets to privately pay until that penalty would be over. Now, it's really dependent on how far you get through the look back too. And that's all stuff we could help you navigate because Medicaid really is a difficult process to navigate. But it really all depends how far you get, how much you would actually have to privately pay. All right, so when's a good time to really consider this pre-planning, to look at transferring assets, shifting them out of your name? It's really whenever you're an empty nester. So you don't have mortgages that you're paying, you don't have college expenses, any children's expenses. You're really just starting to accumulate that wealth, and it's really just starting to be set aside. That's really the good time that we should really look at transferring it then, so it can, really accumulate within the trust, and you don't have that extra penalty like I talked about before. And then also, if you have a family history of certain medical conditions that progresses and might result in needing 24-hour or long-term care in the future, anything like Alzheimer's, dementia, if that runs in your family, any other sort of diagnosis, it's really good to start thinking about this and say, well, there's a high probability that I might have this diagnosis. Let's go ahead and get a plan in place and get things protected. All right, so one of the positives of pre-planning, and one thing I want you guys to remember out of this as well, is even if the crisis occurs tomorrow and you haven't had a chance to do any of this planning, always remember that there are steps that can be taken even if you're already in the crisis or you have a loved one that's already in a nursing home or looking at benefits. There is still planning that we can do. But the good thing about pre-planning and planning ahead, getting through the look back periods, is it really helps you choose how much you want to protect, what assets you want to protect, and you can actually protect a lot more than if we're just trying to, do it in crisis mode where we're already, in the nursing home. So pre-planning really does give you the most flexibility ahead of the crisis. All right, so what can you expect if you were to set up a meeting with us here at Steinbacher, Goodall, and Yurchak? So we really do work in a team approach. So like Tammy said, I'm the attorney, but then, she handles all the Medicaid. She's a certified Medicaid planner. So we really work in a team approach to, meet with you, figure out what your goals are, look at your asset information, and really develop a comprehensive plan of recommendations to make sure that not only your goals are met, but you can really protect as many assets as you're looking to protect. And then we do individualize our planning. So, it's really not cookie cutter. I don't think I've seen one plan that's really been the same for any family or any individual. It's really going to depend on where you're at and what your situation is. So we do take a look at everything and individualize it to, what your specific needs are. And then we do have quality documents. So I know a lot of other firms, it's a paralegal or support staff that's really drafting anything. So I do draft all of our documents here. So I make sure that, everything's done correctly, the laws apply correctly. You're not going to, run into any surprises down the road. So I'm really the one that's looking at that as the attorney and making sure that everything, really is in good order. So, out of all of that, what we hear the most is, people saying, wow, I'm so relieved that I got this done. I have such peace of mind. I'm glad that's taken care of. So that's one of the things that we really hear the most often from our clients. All right, so how are we handling appointments with all this COVID that's going on? So we are still trying to make it as personable and face-to-face as possible. So really what we're offering Zoom meetings where we could do it like this, sort of face-to-face where we could see each other, talk about your circumstances. Or we can do it as a phone conference. So if you'd feel more comfortable just talking over the phone, we'd be happy to meet with you as well. All right. And then after our initial meeting, we can have as many follow-up meetings as we would need, talk about the specifics of your situation. And then we are doing in-person signing appointments to get all of your documents executed. So we would kind of set up a meeting to go over everything, make sure it's correct and what we talked about. And then we would schedule a time for you to come in, review it again, get it signed. And a lot of times you can take it home with you that day. And we are, for those in-person signings, we are following all of the precautionary measures. So we're keeping everything clean. We have shields in between us. Everyone's required to wear masks. We wipe everything down. So we are trying to keep it as sanitary as possible and as social distance as possible.